May it please the court, my name is Chloe Johnston and I'm appearing on behalf of the accused, Mr. Marshall Ike. I submit this application under section 590AA of the Criminal Code for the inadmissible evidence against my client to be excluded from the proceedings. The prosecution's case rests on the evidence that relates to my client's admission to 84 counts of breaking and entering and 1 count of stealing. I will make 2 submissions on behalf of my client. Put simply, Your Honour, my client's submissions are firstly, that the admission that the police obtained from my client in the police car is inadmissible, and secondly, that the record of interview that the police obtained at the police station is inadmissible. To my first submission, Your Honour, my client is 14 years old, and under Schedule 4 of the Youth Justice Act Queensland, he is defined as a child. Therefore, Section 421 of the Police Powers and Responsibilities Act comes into play, where the police have a requirement to refrain from questioning my client before my client has had the opportunity to speak with a nominated support person. It is reasonable in these circumstances to assume that the police were aware of my client's age, and if not my client's specific age, certainly they would have been aware of the fact that he was not an adult. Subsection 2B of Section 421 of this Act stipulates that police must not question a child unless the support person is present during the questioning. Your Honour, the prosecution's evidence clearly shows that firstly, my client had no opportunity to speak to a nominated support person prior to being questioned in the police car, nor was a nominated support person available or present during the questioning in the police car. Put simply, Your Honour, this did not happen, and the police have very clearly breached their requirements in this regard. This brings me to my next point, Your Honour. My client is a Torres Strait Islander person, which would have been obvious to the arresting officers. Again, this would have alerted them that Section 420 of the Police Powers and Responsibilities Act came into play and were to be complied with when questioning my client as a Torres Strait Islander person. Again, Your Honour, this did not happen. Under this section of the Act, the police were required to inform my client that legal aid had been notified, and then as soon as practicable, contact legal aid. This did not happen. In fact, the police proceeded to question my client without alerting legal aid at all. Clearly, the police have breached both Section 420 and 421 of the Police Powers and Responsibilities Act in relation to questioning my client as both a child and a Torres Strait Islander person. The prosecution evidence submits that during the questioning of my client in the police car, he admitted to breaking into 84 properties. Your Honour, I spoke earlier about my client being a Torres Strait Islander person, and this alerts us to take into consideration some cultural issues. In particular, I'm referring to gratuitous concurrence, where it is part of Aboriginal and Torres Strait Islander culture to give non-committal or people-pleasing answers in response to questions posed by authoritative figures. In this situation, clearly, the police is an authoritative figure. This provides an explanation for my client's supposed admissions to breaking into 84 properties. My client's responses of nodding and answering yes when asked questions by the police as to whether or not he broke into these properties is clearly an example of gratuitous concurrence. This brings me to my next point, Your Honour. Under Section 436 of the Police Powers and Responsibilities Act, the police are required to electronically record questioning if it is practicable to do so. On the facts, there is nothing to suggest that the questioning of my client in the back of the police car, that it was not reasonably practicable to question my client in the back of the police car. Again, the police have not complied with their requirements under the Act in this regard. This brings me to my second submission, Your Honour. In respect of this, Your Honour, the recorded interview with my client at the police station, it is clear that the police did not comply with their requirements again, both under Section 420 and 421 of the Police Powers and Responsibilities Act, taking into consideration questioning of my client being a child and a Torres Strait Islander person. Although my client was provided with a support person, as is required when questioning children, Section 421 of the Police Powers and Responsibilities Act specifically states that prior to commencement of questioning, the child has been allowed to speak with a support person chosen by the child, and the person is present during the questioning. The prosecution's evidence shows that yes, although Mary, the support person, spoke with my client prior to the questioning and sat with him during the interview, she was not a support person chosen by my client. Instead, Mary was a support person chosen or allocated by the police. In summary, I urge Your Honour to exercise the discretionary power vested in the court in Section 130 of the Queensland Evidence Act and exclude the prosecution's evidence against my client. Your Honour, it would simply be unfair to my client for the evidence to be admitted to these proceedings. I would like to draw Your Honour's attention to the High Court case of Bunning and Cross. This case established the court's discretion to exclude evidence on public policy grounds where evidence is obtained by illegal means. On application of the factors in this case, it is clear that the conduct of the police was that of a deliberate breach of law rather than a mistake. The police had every opportunity to comply with the requirements both under the Police Powers and Responsibilities Act and regulation in questioning my client both in the police car and at the police station, yet at no time did they comply with their requirements. Your Honour is therefore urged to exclude this evidence as the police obtained it by acting illegally. The defence requests the court exercises its discretion by deeming the evidence submitted by the prosecution as inadmissible. Thank you, Your Honour. May it please the court.